The first matter to come before the court this morning is in re CKAWDB&KE. Ordinarily, both sides have 15 minutes to argue. The state is waived, so Mr. B, you will have 15 minutes to present oral argument on behalf of your client. Please don't use the names of any victims or minors. As you know, we are recording this and it will be posted later on the court's YouTube channel. We have read the briefs and we are ready to proceed with the order.
What was that?
We've read the briefs. We're ready to proceed with the order.
Thank you, Your Honor.
Thank you.
For the record, Attorney James Reed here on behalf of the mother. Can I say her name or not?
If
Just
you
refer
wish.
to as mother.
Yeah, why don't we just keep
Okay.
it? Thank you.
Mother's actually present in the courtroom, wanted to observe today's proceeding. The facts in this case are fairly straightforward if you've read the briefs, as you indicated you did. There's 4 children. There was an incident involving, I think, the 4-year-old child where the child somehow obtained a lighter. She kind of rambunctious, she climbed up, got a lighter, had a baby doll, set the hair on fire, the smoke alarm went off. Mother, who had a friend recently experienced a house fire that ended in a tragedy, went up and disciplined the child. The allegations, and I think the admission by the mother, was she used the belt to spank the child. As I recall, it was 6 or 7 times. After that, I think the child went to a relative's home where I think it was a paternal grandfather or stepfather, who then contacted the police. 2 officers and 2 children's services employees subsequently came out. They, in their discretion, exercised the juvenile rule 6, put the 1 child in custody, and then when, upon learning of 3 other children, went to mother's residence and removed those children as well. And I had 2 assignment of errors. One dealt with the abuse and the other one with the dependency, which pertained technically to all 4 children, but for the removal of the 3 that were at mother's home at the time. We then proceeded to have an adjudicatory hearing. The court, or not the court, the officers, I think on the next day charged mother with misdemeanor child endangering, and that was handled through the municipal court. I wasn't her attorney, but at the time, I think the adjudicatory hearings were going on. I don't recall exactly whether the criminal case had been resolved or not, but on the prior advice of her public defender and my experience as a criminal defense attorney, mother didn't testify at the adjudicatory hearing, which spread over 3 days, and they presented the testimony of the 2 officers and the 2 CSB workers. What they didn't present was any type of medical testimony or medical records from Akron Children's Hospital. It appeared, or my recollection from reviewing the transcript was that the agency or the officers told the relatives to take the child to Akron City Hospital and have the child examined. I'm not sure whether that ever happened or not, because during the adjudicatory hearing, we never received any medical records or testimony from a nurse practitioner or a doctor. And to me, that's really significant, because it was the state of Ohio's burden to prove by clear and convincing evidence that this child is abused. And you kind of have to connect dots between all the various statutes. I'm not going to waste my time. I think everybody knows you have to go to, what is abuse, child endangering, what is substantial risk, and what is serious physical harm. I think that's laid out clear enough in my brief, and probably from other opinions you guys have authored, that I don't need to spend any more time detailing that, but I am going to focus on a couple things. And the primary things I wanted to focus on was, when you do look at all of those statutes and you kind of intertwine with them all, what's, again, I don't want to repeat myself, but the complete absence of the medical records and medical testimony. We don't even know that this child underwent a medical examination and what treatment she received, if any. We do know that the injuries didn't require the alleged injuries didn't require any hospitalization. She was released, if she was examined, she was released without any medication, pain medication or anything like that. She was released without any follow-up appointment for a checkup or anything like that. And I think that's all significant because when you go down and look at those statutes, it talks about what constitutes serious physical harm, and there's 5 statutory items there, and one was whether there was some type of mental illness or something, that's totally inapplicable. Whether there was physical harm that was substantial risk of death, physical harm constituting a permanent incapacity, or physical harm with a permanent disfigurement. I don't think anybody's arguing that any of those 4 apply. The one that the trial court and the magistrate, and even I think CSB and one of the father's attorney that filed a brief, it's number 5 there, the acute pain of duration. Actually, I have the actual statute here. And I guess it was on page 11 or 12 of my brief. But, if I remember right, the allegation of excessive corporal punishment happened on April 24th. The child was seen by the relatives on the 25th. The only evidence we have in the record was 2 photographs. And then the testimony of Officer Sapper, who said she observed the bruises, but she had no medical training. Officer Very, I don't even think, looked at the child, neither did Attorney Weiss, or not Attorney Weiss, intake worker Weiss, and the other intake worker, I think her last name was Carter. They could offer no opinion as to this alleged severity of the injuries because they didn't even examine the child, nor should they, because they're not medical personnel. To me, that's what distinguishes this case from all the other cases we've cited in our briefs, because I went through and looked at the cases that the prosecutor's office cited, as well as mother's attorney, and in each one of those cases, they had a doctor, either by way of an affidavit or testimony, or they had medical records that they submitted, that documented and kind of, I don't think clarified is the right word, but expanded upon whether the bruises depicted in these photos constituted serious physical harm under that acute pain and suffering portion of the statute. By all accounts, when everybody encountered this child, the child was perfectly fine, wasn't in any pain or discomfort, just a normal child. One of the things that the state, and I think father's attorney may have focused on, was they seem to imply that mother, when asked whether she would do this again, and she said, well, yes, at the time, at the very first initial encounter with the police, she said yes, she'd do it again, not meaning that she would harm her child like they were alleging, but she would discipline the child because the house could have burned down and all 4 children and mother could have passed. And I think, we now have the benefit, this case is a year old, my client's obviously got a case plan and done things, she might answer that question differently today, but at the time they seem to be twisting that to say like she would just quote unquote whoop her child's ass again, which is, it looks bad on paper, but the intent of that statement was, yes, I will protect my child and my children from another child burning down a house because I had a friend suffer such a tragedy.
Counsel, can I interrupt you for a second? What about the fact, I think that it seems to me like the court put great emphasis on the fact that it was a belt and the belt buckle, and there was a belt buckle mark, and that, in other words, emphasizing the part of the statute that substantial risk of serious physical harm, even if there was not serious physical harm at this point, but there's substantial risk.
I'm not really sure where Judge Teodosio, in her opinion, focused on the substantial risk of harm, like you said, from a belt buckle. If I took my belt buckle off right now and wanted to spank a child, the belt buckle would be in my hand. You'd double it up and you'd spank a child. I'm not sure how, first there was no conclusive medical testimony that that mark was even from a belt buckle. I mean, we don't know because no doctor examined the child, or if they did, they didn't come to court. To me, the prosecutor dropped the ball here. Had she subpoenaed the doctor or the nurse practitioner, whoever did the exam, and they came in and said, oh yeah, and the officers never got the belt, they never took the belt into evidence. I mean, we don't even know what the belt looks like. I do, my client does, because she has the belt. But, I mean.
When we look at, I'm sorry for interrupting, but when we look at the pictures, you're saying that you can't determine there is a belt buckle bruise or anything?
Well, we don't know if that's, you know, directly the result of a belt buckle. It could have been from playing on a playground for all we know, because we have no definitive medical testimony. I mean, you know, if this was a criminal child endangering case, you'd think you'd have the belt, you'd have a doctor come in. The burden of proof here was not upon us to prove whether or not that was a belt buckle mark. It was on the state of Ohio. And I think they clearly failed to do that. And then what really troubled me was under the standard that the trial court judge employed was anytime, I mean, where she said something to the effect that anytime you hit a child with a belt, there's a substantial risk that you could hit the child in the eye or poke their eye out or something like that. And that's like me trying to argue that, well, anytime you run a red light, you risk committing vehicular homicide. You know, it doesn't always work that way. I mean, you've got to stick to the facts as they exist. You can't just speculate like the trial court does, because corporal punishment is permissible in this country. It's got a long history of being employed. The problem is it becomes excessive. And then, you know, that's when all the statutes kick in. And again, the burden of proof was on the state of Ohio to present the medical testimony to kind of make their case. And every case they cite, in their opinion, you know, some of them are domestic violence cases, civil protection order cases, or child endangering cases. They're not in the realm of the juvenile court where, you know, you're dealing with abuse of a child as opposed to some of the other fact patterns involved in those cases. I don't, does that tell me how much I got? 3 minutes?
That's fine. Thank you.
I'm out of time?
No, I said thank you.
Okay, I just wanted to
That's all right.
make sure I covered everything I wanted to cover. And the state also, you know, there is, I don't know if you want to say it's a litmus test or not, but there are some totality of the circumstances that you have to kind of look at. And it would be the child's age, the child's behavior, the child's response to prior non-corporal punishments or discipline, and the location and severity of the injuries, as well as the parent's state of mind. All of that, I think even when you take it into consideration, that the state didn't meet their burden here. And the second part of my argument is everybody that went out and met with the other 3 children all said the home was appropriate, there were no concerns, that but for the allegation of abuse, they wouldn't have removed the other 3 children. So they were found dependent as a result of the direct Juvenile Rule 6 of the first child.
Now, this was grandmother's home, though, right?
If I recall, I think mother was temporarily staying with the grandmother because she had a mouse or some type of, she was getting her house exterminated or something like that. She's back in her home, and I mean, it's after the fact, but she was temporarily relocated because of the situation in her own home that's been rectified.
The reason why I ask is because I know the trial court determined obviously this under abuse, but there was also allegations that the family was homeless and that grandparents did not want the family in the home anymore. Because it was the grandparents that actually turned basically called CSB.
That was like throwing everything in the kitchen sink at my client, to be honest, from my perspective, because that wasn't a concern at any point in my representation of her through the adjudicatory hearing. I think that got when they file a complaint, they kind of, I mean, they'll go back on these abuse, neglect, and dependency complaints and go back 10 years if they want to, try and portray it as, in effect, damning as possible for a parent. But that was never a concern at the adjudicatory hearing. The focus at the adjudicatory hearing was on 2 photographs, which I objected to because they were supposedly taken by the grandfather, who I'm not even sure authenticated them. And then Officer Sapper was the one officer that actually, I think, said that they accurately depicted the injuries that she observed. Officer Berry, I don't think, observed them, and the CSB workers, I'm not sure, physically examined the child, as I recall. But, in closing, I would just say, if they had brought a doctor in and he had connected some dots, then, maybe we would even have the need to appeal this case. But the problem is, it was their burden by clear and convincing evidence, and they didn't meet that burden, in my opinion. So,
Thank you, counsel.
all right, thank you.
For your presentation today, court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the House Supreme Court website. Thank you very much.
Thank you.